Hey everyone, welcome to WR Immigration's webinar on new immigration options for STEM talent and entrepreneurs. My name is James Pinedo. I am with WR Immigration's knowledge-based team, and I'll be introducing our wonderful panel of attorneys that we have to walk us through all the new immigration options for STEM talent and entrepreneurs that was released late breaking last week. Before we get started, we have some housekeeping to go through. This does not constitute legal advice and is for informational purposes only. For legal opinions, please schedule a consult with one of our attorneys. And a few other housekeeping things, please, we welcome all your questions. Please put them into the Q&A and our attorneys will be actively monitoring that and looking for good opportunities to answer each question. Also, we will be sending out a recording and a PowerPoint handout in an email to all registrants afterwards. So don't worry, you'll be able to access all this great content. A little bit about our firm. WR Immigration is a top-rated immigration law firm that provides strategic, client-centered services. We recently were awarded, named a diverse, equitable, and inclusive workplace by Diversity for Social Impact, and that's one aspect of our firm that we really focus on and always try and we bring that out with everything that we do. Another big focus of our firm is Rapid, the next generation of immigration management software. It really makes all of our clients' life a lot easier, and we work hard to improve it every day. Now, on to our presenters. We have a wonderful panel today, moderated by Sharina Garcia. Maybe, Sharina, you could take it from here and introduce yourself.
Sure, no problem. Thanks, James. I'm Sharina Garcia. I'm based here in our Northern California offices. I've been practicing for over 20 years, and my special focus has always been in the tech startup entrepreneurial space. And I'm really excited to be able to speak today about our late breaking news and all the new changes that the Biden administration has made. And with me, we have Melissa Harms. So I'll let Melissa introduce herself.
Thanks, Sharina. Sharina and I have both been practicing over 20 years. We grew up as baby immigration lawyers here in the Bay Area. And like Sharina, my practice focuses on small startups in the technology spaces and also biotechnology companies. So I've dealt with a lot of STEM students and also entrepreneurs. Nate, I'll turn it over to you.
Hi, I'm Nate Groh, Senior Associate here in Oakland as well. And WR, does anything and everything immigration. But like Sharina and Melissa, my interest and my passion really lies in helping entrepreneurs, investors, startups find visas and green cards for their employees.
Thanks, Nate. So we'll just take it away. So last week, the Biden administration announced some changes, and many of it, well, actually, all of it is focused on the STEM, so science, technology, engineering, and math, and then also the entrepreneurial space. And so basically what was introduced were a bunch of initiatives to really bring entrepreneurs and allow STEM talent to remain in the United States. And the goal really is due to the innovation that many of these immigrants bring to the United States, the creation of new jobs, new industries, and then of course, new opportunities. And what we're going to discuss today are the different programs that we had heard about that have been updated. Now, you may have a lot of questions, but just remember, this was just implemented last Friday. And so we may not have all the answers for you. But if you continue to follow our news alerts and our blogs, you'll be able to see some of the updated information we get as we get it. So I'm going to talk about the F1 STEM OPT and what changes have been made in that arena. Melissa will cover the J1 and the new early career STEM initiative and some of the changes to the J1 academic training. And then Nate will cover the O1 extraordinary ability and the national interest waiver and the new guidance we've received. So moving on to the next slide, this is about the STEM OPT changes. So STEM OPT is basically once an international student graduates in a STEM field, they are given 1 year of what's called optional practical training And then if they graduate from a STEM field, they'll actually be given an additional 24 months of practical training. So a total of 3 years of training. And so the way that it's determined how you get this additional 2 years is based on what we call the STEM list. And so I've provided a link here to the STEM list. And this list basically designates different what we call CIP codes. And these CIP codes will determine whether your major is covered under this STEM optional practical training and you're able to get an additional 2 years. So the codes are 14, 26, 27, and 40. So historically, the categories that are under these codes were just the traditional ones, but we know that science is always changing and there's always new majors that are cropping up. Like when I first started, they didn't call it data scientists or data analytics. I think that was just all lumped into computer science, but now there's a specialization called that, and that's actually what you'll see in these new codes. And then the codes can actually be, you can actually add different fields to these codes. And one of the ways you do it is by nominating a field of study, which may have happened here. And that's why they added these different fields. But to be honest with you, many of the majors that are at the various universities, students will typically, or the academics will actually talk to the department and see if they can actually reassign one of the fields into one of these codes. So you could actually be able to still get your STEM OPT extension. So as I go through the new fields, if you don't see your major there, it doesn't mean you still can't get STEM OPT. What we do recommend is you actually go to your university and your department and see if you can get it coded under these CIP codes that are actually accepted as STEM fields. So we can move to the next slide. And so here are just some of the examples of the new fields that have been added, like bioenergy. I think a lot of these, to many people, it's like, why weren't these originally STEM to begin with, right? And I think that the ones that we've seen that has really made a difference now is in the psychology space, because now it's official. People that have a degree in the psychology space would be able to qualify for the STEM OPT. And then also the data sciences and data analytics that I had mentioned before. So that's some changes there about the STEM OPT.
Before we finish, Sharina, can I ask you a question?
Yeah.
If I'm already on my STEM, if I'm already on my OPT for 1 year and now all of a sudden my zip code major is eligible for the STEM extension, can I take advantage of that, or is this only for new graduates?
Yes, you can take advantage of that. So you should go to your foreign student advisor and ask them and process all the paperwork so that you can get the STEM OPT. Now, just remember, your employer still has to be an E-Verify employer to get the 2 years. But now that these fields have been added, you can now get the extra 2 years of STEM OPT. Thanks, Melissa. And I'm going to pass it back to you so you can talk about the J1 basics and the new changes in the J1 world.
Thanks, Sharina. So J1 visa is actually a different visa from a lot of the other ones we use. And a lot of visas are administered by USCIS, and we work directly with USCIS to approve, whether it be H-1B, L-1, the different statuses. J1 is run completely by the State Department. And the State Department has an entity called Bridge USA that's facilitating the J1 program. It's really designed, and it came about, I believe, in 1961 as a program to spread US ideas abroad and establish an exchange of information and ideas between the US and other countries. So the program is not really a work visa program. It's really a program to facilitate the exchange. So these are the different categories listed here. There are actually 15, not 16, and I'll talk about that in a minute, why there's 16 on this list. The J1 can be valid anywhere from 6 months to 5 years, depending on the different program. All of these programs have their own regulations and their own limitations and advantages. most commonly what we see as immigration attorneys, we do a lot of J1 trainees or J1 interns. We also sometimes will do research scholars. So those are the most common ones we're going to see. But of course, I'm sure you all have seen some of the other categories as well, such as au pairs and camp counselors. There's a lot of J1s out there. Okay, so going on to this new early career STEM research initiative. So initially we got all very excited. We thought, oh, there's a new J1 program category, and maybe this is going to offer lots of different options for our clients. Well, in reading the preliminary information, and as Sharina said, this is coming about, or as James identified, this all happened on last Friday, the 21st. So we're still trying to process what this means. But this early career research initiative is using the programs that are already in place. So it utilizes those other 15 we listed. So you still have to qualify for one of those programs. There's no new requirements for this. It's really a facilitation of information between hosts and sponsors. So if you are a host, that means you're actually where the J1 researcher or the J1 scholar is going to come. If you're a sponsor, you're the one that's in charge of administrating the program. So this is really designed as a way to facilitate that exchange between the host and the sponsor. If you are interested right now in looking into this, and I'll go into a little bit more what it's about, there's a statement of interest form that we have on the presentation here, and you can go ahead and click on that. It's a very short form, but you basically just identify yourself or your company as a place that you would like to hire STEM, early career STEM individuals, and then they will match you up with the sponsor or with the sponsor. Okay, so now let's move on to our handy dandy flow chart here. So I like to call this early STEM research initiative the Match.com of J1s. Like I said, we have no new category here, but what this is a way for hosts particularly to sign up. And the host again would be the company that wants to host the J1 individual. So they host up and say, I want to host these J1 individuals in the STEM fields. And then the sponsors, and these sponsors are traditionally nonprofit entities that administer the J1 program on behalf of the State Department. So these J1 sponsors will say, I want to help these hosts facilitate this J1 program. So I want to sign up too. So these two hosts and sponsors both sign up and say, we're interested in the early STEM research initiative. Please facilitate our names and share our names with each other. So Bridge USA will do that. And you will have to identify which categories between the hosts and the sponsors you want to sponsor, whether it's J1 interns, trainees, research scholars, which program do you think your organization can support? And then you will be able to interview the eligible exchange visitors. So that's basically the process here. You are really just going to be working directly with the sponsor, but Bridge USA is going to help you find those sponsors for this program.
So Melissa, can I ask you a question? So let's say I'm an employer and I have this new research or whatever I need to get done, and I want to bring in interns from overseas, and I want to bring like 20 interns, right? How does that work with this program?
So what you would do is sign up to be a host. You will sign that host statement of interest, and then Bridge USA should match you with interview sponsors. Right now, we've spoken with some sponsors, and they're just now completing these information. Obviously, this just came out on Friday. So they're completing the same statement of interest on the sponsor side. What's still left to be seen is how long it's going to take Bridge USA to facilitate that that information exchange. But once they do, then you'll follow the normal J1 process to work with the sponsor to issue the DS 2019s for those individuals to come in and start your program.
So how is this different if I've already identified the 20 people I want to bring? How does this program help me?
This program helps you if you don't have a sponsor that's willing to do it with your company. So if you've already been working with a sponsor, you're going to follow you're under the same research category, the same research scholar, trainee, or intern category. So it's not going to change anything fundamentally. This would really be, it's designed to help these new hosts come up with a solution for these STEM research J1.
So basically, if I'm a company and I need interns, but I haven't identified the interns, and I can actually sign up here and then sign up to be a host. And then, like you said, it's like a match.com. The students will actually sign up as well, and then they'll just basically match us, right?
Yes, if you look at the J1 website right now, they have a list. If you, let's say you wanted to bring in a research scholar and you said, I don't know which sponsor could help me bring in some research scholars for a research project in my organization. You would look on the J1 website and it populates with thousands of names of J1 research scholar or sponsors that can do J1 research scholars. However, most of those are universities and they're not equipped to set up a program with a private company. So this is a way to just help them find the host or help them find the sponsor when they want to institute a program like this.
And then how about if I'm an F1 student and I've, used up my OPT, does this help me in any way?
Probably not. You're still going to have to follow the rules for your specific program. If you wanted to move to the intern, for example, the intern and the trainee J1 categories both require you to have a degree from outside the US. So you would not be eligible for that. So most likely not. There are some programs that do allow for a US degree. So if that program worked for you, you could investigate that.
Yeah, so I think what we're trying to tell you is that nothing's really changed in terms of the programs and the researcher, intern, trainee. It's just that if you haven't identified interns or trainees or researchers, you can use this Early STEM Research Initiative program to actually locate and find individuals to bring to the United States to do this STEM initiative, right?
That's exactly right. It's a way to encourage businesses to utilize this program.
Okay, and then can you tell us about the J1 student changes?
Yeah, so the J1 students, just to give a little primer to everybody, there is a J1 category, and among those 15 we listed called a college and university student. So these college and university students are a little different from the F1s you might have seen. They traditionally are coming here, they have program funds, their program is funded through either their foreign government, the US government, or maybe a non-government research or a non-government entity. They're traditionally through, it's usually an agreement between two schools, for example, to share students back and forth. So it's not a traditional, I'm going to sign up, apply to a school, and then get my F1 I-20. So those are the use of the college and university student program. Okay, so moving on to what is this new academic training? It sounds a lot like OPT. So this is for students in a STEM-related program to get a total of up to 36 months after they graduate. In the past, the limitation was only was 18 months. And this is for people who are getting either a bachelor's or a master's degree. Those who are getting a PhD degree already had the 36 months, which really no change for them. They can apply for this no later than 30 days. It's like the OPT program in that their degree program in the zip code has to be one that's eligible for STEM. So they'll follow the same process where they have to make sure they have an eligible STEM code on their DS 2019. This initiative is going to run for the next two academic years. So this is not permanent. This is for this year and next year. My guess is they're looking to see how this goes, if it really benefits people, and they see a good reaction and a favorable use of the program. This is not for non-degree seeking students. So for example, if you had a student who was studying abroad, like a lot of US students will go abroad, spend 1 year and come back, they're not going to be eligible for this program.
So Melissa, can I ask you, who actually enters on a J1 academic student?
Not many people. So we we were talking with one of our large university clients yesterday. They have about 30,000 undergraduates, and the director of their for their student international students and scholars program said that he estimated maybe one wow. person, 30,000. So there's not a lot of people who are using it. It's a very finite use of the J1 program.
But we've seen them with our Fulbright scholars, right?
We see Fulbrights, and that's really the quintessential use for a student because it is an exchange, and there is a program between the US and the foreign government to facilitate that exchange. So Fulbright scholars would undoubtedly be on the J1 for students.
Okay, thanks, Melissa. Now let's move on to the O1, and we have Nate here who's going to kind of guide us through all the changes in the guidance on how the USCIS is to adjudicate these applications. Nate, why don't you take it away?
Thanks, Sharina. So yes, another component of the Biden administration's initiative to attract STEM talent and strengthen the US economy and competitiveness has to do with the O1 non-immigrant visa category. So the change here is that USCIS has added some materials and some clarifying language to the chapter of the USCIS policy manual related to this category. And just as an overview, we see these changes as potentially only a small incremental improvement that may make O1 a category that is a little easier for some people to qualify for. But there's nothing earth-shaking in these updates. So before we get into exactly what those changes are, let's first discuss a little background. So what is an O1 visa? O1 is divided into two categories, O1A and O1B. O1A is a category for extraordinary ability in the sciences, education, business, or athletics. O1B, which we're not going to discuss in depth today, is a separate category for extraordinary ability in the arts, movies, and TV. So O1 is a non-immigrant category, so it's for people who are here temporarily with an intent to go back to their home countries. And people in O1 status are eligible for up to 3 years of status, which can be extended without any limitations. You can get as many extensions as you want. O1, the criteria requires sustained national or international acclaim within a specific field. And you can show that either through a major internationally recognized award. So that's a very slim category. You're talking about like a Nobel Prize. Or how most people get there is they show that they meet at least 3 out of a list of 8 criteria. So let's go to the next slide. And so USCIS has added a new appendix in the policy manual. And there's some substantive discussion regarding these 8 O1A criteria. And based on our experience with O1 petitions, none of this new material really represents a significant departure from how USCIS has been adjudicating O1s in recent history. But there are some clarifications that are good to just have in writing in a form that we can refer to. We've seen many of these types of points that they've added here in requests for additional evidence from USCIS in connection with O1 petitions. So it's nice that we have them all here in one spot. And now if we see points raised in O1 petitions, RFEs going forward, we can respond and cite to this new appendix to show that somebody's achievements meet the criteria. So the first of the O1A criteria is nationally or internationally recognized prizes or awards. So historically, we've seen RFEs where somebody's prizes or awards are related to their education, something that they won, something that they were recognized for as part of a master's or a PhD program or something like that. The additional appendix clarifies that certain scholarships and awards related to education can actually count toward this criteria, which is a good clarification. Second criteria.
Isn't that kind of big, Nate? Because whenever we are looking at our clients' questionnaires, they always tell us about all these educational awards they've received. And we're like, oh, sorry, the government's not even going to look at that. So now they may look at it.
They may look at it. They were looking at them before, I think. If you can show that an award goes more, beyond just your program, if other people were eligible, or if it's like a PhD where you get some kind of a sponsorship or award, that's where you've been selected from a larger pool of people, or if you're talking about recognition from a school or academic institution that's got an outstanding reputation, that helped before, and even more so now that we've got this clarification.
Thanks.
So number 2, membership in associations that require outstanding achievements. So the helpful clarification here relates to the STEM and tech world. You know, in certain fields, there just aren't a lot of organizations that select people for their outstanding achievement. And O1s can be tricky. They're not a good fit sometimes for your software developer, electrical engineer types. So a good clarification here was that if you are at the fellow level with the Institute of Electrical and Electronics Engineers, that can count for this membership criteria. Same with if you are at the fellow level for the Association for the Advancement of Artificial Intelligence. Before, that's kind of been one where we say, maybe that works, maybe that doesn't. Now we've got a clarification that works. Criterion number 3, published material about the foreign national and their work. So a helpful clarification here is that USCIS will accept transcripts of professional or major audio or video coverage. So we've had lots of candidates that come to us and say, well, I was on a podcast, or I was on a TV show. And in the past, we kind of say, yeah, maybe that works. We've submitted that with O1 petitions and it seems to have worked, but now we've got a clarification. So that's good. Original scientific, scholarly, or business-related contributions of major significance. So this is kind of the most, the least objective. This is a criterion where we see a lot of pushback from USCIS, where we want to say something is original and of major significance in the field, and they can essentially just say, no, it isn't. It doesn't seem like it to me. And something that we've seen in a lot of RFEs is where we cite to an entrepreneur's funding, or where we cite to publications or an innovator's patent as evidence of original scientific contribution of major significance, they will come back and say, you know, just because you got a patent, that doesn't mean that it's significant. You have to show something more. And they gave examples. So if you can show that there's widespread commentary about what you've done, if you've got a publication and it's got high citations, or if there is commercialization, whatever your innovation is, if you can show now somebody's making money off of it, you or a company is making money off of your innovation, that goes to original contribution of major significance. All right, publication of scholarly articles in professional journals or other major media. So one clarification that I'll note from this section is that USCIS considers the journal's impact factor, and they'll look at any other evidence you submit of how highly ranked a journal or other publication is. This is helpful, but it's also a reminder of just how subjective USCIS can be with these criteria. You know, whether you've published a scholarly article or a professional journal is something objective. You can say yes or no, but USCIS maintains the ability to say, well, sure, you published that, but that journal's not good enough. It doesn't have a wide enough reach. And there is no hard line as to what type of circulation or what kind of impact factor is good enough and what's not. It's left to the officer's discretion. Finally, a high salary or other remuneration is a criterion for O1 extraordinary ability. So we have long used for entrepreneurs, not just their salary, but their equity holdings. You know, an entrepreneur, somebody with a startup, usually is not paying themselves a high salary. A lot of their compensation comes from the equity of in the company that gets a big payoff if the company grows and succeeds. So we usually include that. Now we've got a clarification from USCIS that officers should consider that equity in addition to salary or other remuneration. So another criterion, participation on a panel or individually as a judge of the work of others in your field. A lot of times with our employees will get people submitting emails showing that they've been selected to conduct peer review for a scholarly journal, which is great. What we've always told them and what is now clarified here in the policy manual is it's not enough to be selected to be a peer reviewer. You have to have evidence that you actually did it, that you actually conducted the peer review. So you need maybe the email or the screenshot showing you were invited, and then another one showing you did it. You did the peer review. Employment in a critical or essential capacity for organizations and establishments that have a distinguished reputation. So here it was helpful, USCIS added some examples of the types of roles that can meet this criterion. And one of the examples that they added was founders, co-founders, and individuals that contribute IP to startups. And again, this is something that we, and I'm sure lots of immigration attorneys have relied on for an entrepreneur, for a startup type of O1. You want to show you got a new company, and obviously a founder or somebody who contributed their IP is a critical role. So USCIS confirms that works.
Hey, Nate, for the publications, how about if it's just an online sort of internet publication where they talk about the individual? Are they saying now that they'll accept those? And if the web page has a lot of hits, or however you can monitor that?
Yeah, you mean, so like press coverage that mentions an individual and their achievements, and if it's only online?
Yeah, it's not like the New York Times or anything like that. It
Right.
may just be specific to that particular industry, but it has a lot of, traffic on the site. So does that mean that the USCIS will now accept those types of evidence?
They will accept that kind of evidence. They do leave themselves some wiggle room. They could always come back and say, well, that website doesn't have enough traffic, or that website is not really major media. But yes, it works. We submit that for press for people, stuff that's just online, and it has worked in the past.
So what didn't change that should have changed?
Right. What did not change? So next slide, please. So, as immigration attorneys, we share lots of frustrations about what categories should be and what they're not. So I've kind of already mentioned that USCIS will be arbitrary and unfair in saying that you don't meet criteria when you've submitted evidence that ought to be sufficient. And sometimes they're just wrong too. So they will misquote, they will misstate the standard. They will tell you stuff that is just wrong, and requests for evidence are in denials. And that none of these changes really fix that. It just maybe gives us some more ammunition to point them in the right direction. And O1 also, we talked through those criteria, but that's not the whole story. To qualify for O1, you need to show that you have extraordinary ability through 3 of those 8 criteria. And then the officer is supposed to look at the totality of the evidence to see if that makes you someone among the top percentage of your field. Very, very subjective, very wishy-washy. Leaves the officer room to say, sure, I see 3 out of the 8, but not good enough. And then also, O1 has a green card category that is very similar, EB1A. EB1A is a category through which you can get a green card, not just a non-immigrant visa, for your extraordinary ability. And the criteria are the same for EB1A. Nevertheless, we all know that what works for an O1A may not work for an EB1A. They're just much more strict on those same criteria. The bar is higher. And there's no regulatory reason as to why that is. It's just how USCIS adjudicates. So what would be helpful is a similar type of update and clarification for EB1A that explains just how and why officers can look at the same regulatory language for EB1A and apply such a higher standard.
So Nate, for O1s, can individuals who are co-founders qualify for an O1?
Individuals who are co-founders, yes. One thing in the entrepreneur startup world to be careful of is that you have to have an employer-employee relationship. You can't be your own boss to be an O1. So sometimes co-founders, startups with no other employees, that can be tricky, but there's ways to get around that.
Yeah, thanks. So why don't we talk about the changes, or not many changes, in the national interest waiver world?
Right, so national interest waiver is a green card category for individuals with advanced degrees or extraordinary ability who are working in an area of national interest. And so like the O1 category, USCIS has updated their policy manual to clarify and explain how this category can work for entrepreneurs and for STEM workers especially. So yeah, the takeaway here again is that there are some incremental changes and some good clarifications, but nothing that really moves the needle that much. Maybe there are some additional folks that we could consider for this category that we perhaps would not have considered as strongly before. But a lot of the updates here are things that we already knew. So the standard in this category is you have to show that you're involved in an endeavor that has substantial merit and national importance. And then you have to show that you are well positioned to advance that endeavor, and that on balance, it would be beneficial to the US to waive the requirements of a job offer and a labor certification. Well, labor certification is we know from the PERM process. The PERM process is a more general category for getting a green card. The national interest waiver, the waiver is a waiver of that requirement for the job certification that comes through the PERM process. Right, so NIW and entrepreneurs. So the policy manual has been updated to clarify how this category works for entrepreneurs. But before we get into it, this is not really a new development. We have been working with entrepreneurs for years to get them green cards through this category. And there's been talk for years about how NIW is for entrepreneurs. In fact, under the Obama administration, there was an announcement that USCIS was going to issue some clarifying guidance regarding NIW for entrepreneurs. And so this is perhaps the guidance that we are getting now, which the Obama administration had called for 7 years ago. So the policy manual now says that officers may consider factors such as equity ownership, a founder or a co-founder position, selection for incubators or accelerators, funds from outside investors, or a history of successfully leading startups. All of that can be evidence supporting an entrepreneur's NIW position, showing that they are engaged in an endeavor that is in the national interest and that they are well positioned to advance that endeavor. So entrepreneurs are not required to establish that their business is more likely than not to ultimately succeed based solely on the revenue, profitability, or valuations. So in the past, and actually there are some AAO decisions that you can find where entrepreneurs have been denied for this category, essentially because the officer thinks this isn't much of a startup idea. This company isn't going anywhere. I don't think this company is going to succeed. I don't think it's going to create jobs. Therefore, not well positioned to advance the national interest, denied. So this is a clarification that you don't need to show you're going to succeed. You don't need to prove it. It's okay to have a business with just an opportunity, with the possibility of creating jobs, and that can be the basis of an NIW.
So Nate, we see a lot of serial entrepreneurs, right? And not all ventures are going to succeed. So are you basically saying that even if we have a client that has created many startups, but it hasn't been sold, it hasn't been acquired, it hasn't, really taken off, right? That this person may still qualify under this criteria, national interest waiver?
Yes, and it's especially valuable for those serial entrepreneurs who are moving from one project to the next. Because an NIW, you can apply for a green card. It takes a while. You can change jobs. You can change to the next venture while your NIW, your green card is pending, and still get a green card as long as you're still working in the same area of national interest. The same is not true for the perm process. For the perm process, you get trapped with the same employer for a while until you get to a certain point in the process. So this is what makes it especially valuable for entrepreneurs. Next slide, please. So the policies have also been updated to emphasize how NIW works for STEM fields. So the policy manual now says that workers in STEM fields are important, particularly if you're talking about people who are working in critical and emerging technologies and areas that are important to US competitiveness or national security. This is helpful language to have. You know, usually with NIWs, when we are trying to show that something is in the national interest, we gather legislation, initiatives from federal government agencies, policy statements from politicians, especially the White House. And you know, we find that kind of stuff in areas of critical and emerging technology like AI, like machine learning, like quantum computing, like, you know, areas that are on the cutting edge of technology. USCIS has updated the policy manual to emphasize that letters and other sources from government agencies or quasi-government agencies are helpful evidence for showing that something is in the national interest. So the helpful change here now is just a little more guidance as to what we go look for our clients to show that what they're doing is in the national interest. Next slide. So as with 01, you know, I don't want to be Debbie Downer. We appreciate the clarifications, but there's more that's left on the table that could really improve things in the NIW world. Adjudications are very slow right now, perhaps due to COVID and due to understaffing. USCIS's website says that they can take 11.5 to 27.5 months just to approve the NIW portion. That's not even, then you get to your adjustment of status application to get your green card. And most we have are not taking, I don't have any taking as long as 27.5 months, but I've got several that are pending for over a year now. And it would be good to see that move faster. There is a framework for USCIS to add premium processing for this category and for others so that you could get an adjudication within 15 days. USCIS could do that if they have the people to make it happen, but that has not happened yet. And then, you know, what else is still frustrating about NIW is that there is discretionary language in the policy manual and the regulations. It's not like 01, it's not a category, it's not an objective category where you can say I've done ABC, so I qualify. There is room for officers to be arbitrary and to deny petitions for subjective reasons. And it would be good if there was more concrete language in the policy manual or added to the regulations so that it's more clear. When somebody is choosing this category and they're going to wait over a year to see if they qualify, it would be good to have more reliability to tell them you're going to get it.
So Nate, if I was told before that, you know, my 01 didn't meet the criteria or my NIW, should I go back and reconsider it now?
It would be worthwhile, yes, to reach out to your immigration counsel and ask them and say, you know, before this was looking like a stretch, how about now under these new changes? Is there anything added in that very helpful appendix for 01 or in these updated guidelines for NIW? Is there anything added that could make me a stronger candidate? And in some situations that might be true.
Yeah, I think the reality is, you know, for us as practitioners, we actually have already been using a lot of this guidance in preparing our petitions. It was just never actually in the USCIS manual that these were acceptable forms that could lead you to a successful, you know, application. And so I guess what I'm trying to say is WR has historically utilized all of these things that Nate talked about, right? And whenever we would advise clients, we're like, well, you know, your chances of success could be this, but I think now because it's actually in the guidance, we can actually say your chance of success are higher, right? Because we only were using what we had seen in prior approvals as what's been acceptable to the Immigration Service. And now it's actually in their policy manual that these types of evidence is actually acceptable for an approvable case.
Yeah, that's true. You know, you don't get a report card when you file an O1 or an NIW where they say it's approved because of ABC. You just get an approval. When you get a request for additional evidence, that's where you get some insight as to what's good enough for them and what's not. Yeah, it is frustrating that you don't always know. You can't know 100% what's going to fly and what's not.
Yeah, and you know, there are some examples we have of clients that, you know, we may already be pursuing the O1 for them or the NIW, or even their NIW is filed, right? And now we can say to our clients that, you know, you probably have a higher chance of success or approval than what we thought when we originally filed your application or we originally started your application. So that's a positive thing, I think. You know, is that we can hang our hat on the guidance now versus before we didn't actually have the guidance. So incremental changes is good. So we have a bunch of questions. So why don't we move to some of the questions? So I'll just kind of go through some of them. Does an O1 need to be sponsored by a company? So do you need to actually have a company sponsor you for an O1? So Nate, you want to answer that one?
Yes, O1 is a category that requires O1A it needs to be sponsored by a company, or it can be sponsored by an agent. If you're in the gig economy and you've got more than one thing going on, you can get an agent and get authorizations to do more than one thing. But you do need to have an employer-employee relationship. If you're a startup starting your own company and you've got all the equity, then O1 can be risky. It could be problematic because they're going to say you need an employer-employee relationship.
Okay, and then can you tell us a little bit about the non-immigrant intent? Is it a dual intent for an O1 or a single intent, quasi intent? How does that work for an O1?
Yes, that is a great question because it is a little more complicated than what I indicated there on the slide, that it's non-immigrant intent. So you know, in the regulatory language, it requires non-immigrant intent, but you know, there's a section of the FAM that clarifies that it's really kind of more mixed. You're not going to be denied an O1 visa. You're not going to be denied entry to the U.S. with an O1 visa if you have a pending adjustment of status application, for example. But it is technically on the books a non-immigrant category. You're supposed to have the intent to be here temporarily.
So we call it basically a soft intent, right?
Yeah.
So, you know, you can pursue adjustment of status. You can probably even try and pursue your O1 extension. And it's not more of a hard and fast rule that we've seen in other situations. So it's more like a soft intent. Can STEM graduates with advanced degrees apply for NIW? You can apply anytime, honestly. You could apply while you're still in school. You don't have to have a specific degree. We've done many NIWs for people who don't even have a degree, right? It's really about what can you contribute that's going to be in the national interest of the United States, right, Nate?
That's right. Yeah. You know, technically in the standard, you must first have an advanced degree or extraordinary ability. There's a different extraordinary ability criteria specific to NIW. You've got to have one of those. But yeah, a recent graduate can get there. There is maybe just a little bit of bias in the O1 and in the NIW world of, if you're right out of school, how extraordinary could you really be? You know, we've perhaps seen a little bit more scrutiny for recent graduates.
But I think for NIW, you just have to be exceptional. I don't think you need to be extraordinary, right? You just have to be able to meet the exceptional. If you don't have a degree, you could, as long as you can meet the exceptional ability criteria, then you could have a shot at the NIW. So, you know, I think it's important that, I love the NIW. I think it's one of the most creative categories to utilize and see if people can qualify. And if you can hit that one prong of whether you have exceptional ability or an advanced degree, then, you know, I think it's a viable option for many people.
Agreed. And for example, if you're talking about a STEM graduate, maybe you've got somebody who's done some research that they think has got a strong commercialization possibilities, and it doesn't have to be realized already. You know, you don't have to show that you're making a bunch of money from your idea. NIW leaves open the possibility that you can argue, I'm going to get there. I have a chance to get there with a great idea, so I qualify for NIW.
Yeah,
It's a much lower standard than the EB1A extraordinary ability, and it's self-petition, so that's a great thing.
yeah. So usually we do look to see if someone can qualify for an NIW. And then, do we know the answer to this? What is the definition of a quasi-governmental entity? Do NGOs or think tanks count?
Yeah, they put that language in there and did not put a definition. And I was wondering that myself when I read that. I think how that term is usually used is maybe more in the world of a private sector organization, company that also has some governmental function. I don't know if that could maybe be a think tank.
Yeah.
I'm not sure about an NGO. So it's, you have to come back to national interest. You know, you're talking about an entity that's going to write you a letter that's showing that there's some national interest. I'm not sure if maybe they might discount an NGO saying that this is an international organization and is not speaking to US national interest.
Yeah. And then can someone on H-1B looking to apply for an EB2 NIW as an entrepreneur, founder, or co-founder of a business without running afoul of the H-1B visa rules? It's just like Nate said, right? You have to still have that employer-employee relationship. And so, you know, you can do an NIW, right? Even if you're on an H-1B or you're on an O1, but you just have to make sure that you're still in compliance with your H-1B rules and the O1s. So yeah, you know, we have done NIW for people on a variety of visa types, including H1, O1E, like all kinds of visa types. But you just always have to maintain your underlying status. And you also have to make sure what you put in your NIW application is consistent with what you put in your H-1B, right? Because I've seen a lot of people say, you know, can we say this, that I'm the president or blah, blah, blah. And I'm like, well, what's on your H-1B? And it says, I'm a software engineer. I'm like, well, I don't know. Like, can we really do that? Or I was on a J1 and I did this, this, and this. I said, well, if you're on a J1, then how could you have done this, this, and that? So I think you really have to be careful when you pursue another different green card option to make sure there's consistency in what you're saying.
Yeah.
If I'm already on another visa like an H-1B and have a job in the US, would that make getting an NIW easier? If my NIW is rejected, does it affect my current visa? So Melissa, Nate, you have any answers to that?
The NIW is not going to affect, like you said, you just want to make sure that you're not saying something different in your NIW that's in your H-1B, but it doesn't affect your visa status. It's a green card. You do want to make sure whatever your underlying visa status allows for you to be applying for a green card.
Yeah, and I think there's like a misconception that you actually have to be physically in the US working to be able to qualify for an NIW. You have to remember that these NIWs are for future employment. So I could have someone living and working in the UK, and they're going to be offered this amazing opportunity in the US in the future, and I could still file an NIW for that person. That person would just have to process their visa abroad at the embassy in London. But I think that, you know, people, I mean, yeah, maybe it would be better, yes, stronger evidence because you're already here doing and working in that field in the United States. But it doesn't mean that you can't, even though you haven't been working in the US. That's right.
I think from a practical perspective, it's hard, especially when you're looking at 27.5-month processing times. Most people want to come in and get, you know, in another visa status, but they don't have to.
Yeah. Yeah. I mean, the practical side of it is the hard part, right? And then does advanced STEM degree combined with experience in the field qualify the candidate for NIW, or the perm is required to convert from L1B to green card? Whoa, did you guys get that?
Yeah. So does the advanced STEM degree plus experience get you to an NIW? I mean, it depends on that experience, depends on what you're doing. You've got to show that you're working in an area of national interest and that you're well positioned to advance the endeavor. So it can, something you should talk about with your immigration counsel to see if it would work for you.
I think the thing is it's two-pronged, right? So first of all, do you qualify even for the category because you meet the advanced degree requirement, which is a bachelor's degree and 5 years of progressively responsible work experience, or a master's degree, or the alternative is exceptional ability, right? And then the national interest waiver component comes into it too. So yeah, if you have an advanced STEM degree like a master's, well, you already meet the ability to apply, but whether the work you're doing is actually in the national interest is another thing you need to prove, right? And is the perm required to convert from L1B to green card? There's never a requirement to do a perm. You could go from NIW, you could go from L1B to NIW, but you may not have the qualifications needed. So we always have the same question, like, should I pursue an NIW or a perm? And it just really depends upon the timing, right? I could probably get you through a perm faster than I can get you through an NIW right now. And so we really look at all these different factors. We have a minute left, so I think we could get through some of these questions. At what stage of the perm process are you allowed to change employer without losing your application? Melissa, you want to answer that real quick?
Well, it's kind of a little bit of a complicated situation. If you basically are going to need to have your adjustment on file for 6 months before you can change employers and be fully able to move. However, you can get your place in line or your priority date after your I-140 is approved, which is the next step after the perm process.
Yeah, so basically what stage in the perm process are you allowed to change employers without losing your application? Once you leave and you're in the middle of the perm process, you have to start all over again. So yeah, you will lose your application the minute you leave if your perm is still pending with the Department of Labor or hasn't been filed. Is it possible for someone to move from H-1B to O-1? Yep, we do it all the time. Are there age limits? I'm not sure what the age limits are for.
There are age limits for some J1 categories. The au pair, I think specifically you need to be, I believe it's 25, under 25. You know, one thing I want to point out before we end is that, you know, a lot of this seems very negative, that we're not seeing a lot of changes that we'd like to see. But I think from the top down, what we see in adjudications is things change. And this is a signal to the adjudicators, hey, we want to see more applications approved for the NIW or the O1. So it's not all bad news. It is a signal that adjudications, we hope, will change for the positive.
I don't think it's bad news at all. I think it's actually positive, even though if it's a tiny step in the right direction, at least it's a step, from where we've been like 2 years ago where there were no steps and we were going backwards. I think it's still a positive step that we're moving towards. That's really going to help our clients, and I'm hoping that there'll be more coming from the Biden administration based on what we were told during the inauguration a year ago. So we're at time. So I want to thank Melissa and Nate and also James and Frank for helping us with this webinar. We hope you found it useful. If you have any additional questions, we've put up our email addresses here. You're more than welcome to email us, and good luck, take care, and hopefully these changes are beneficial to you.